Hi everyone, Derek Johnson with Tatango.com. Today I'm talking with Joe Bowser from Innovista Law. He is part of the TCPA defense force here at Innovista Law. We're going to be talking today about double opt-ins for text messaging. So there's a lot of confusion if a double opt-in is required by the Telephone Consumer Protection Act, which is essentially the federal law that protects consumers from receiving text message spam. So Joe, let's answer this once and for all. Double opt-in, is it required in the Telephone Consumer Protection Act?
Short answer, no.
Okay. And by that you mean it's not mentioned in the Telephone Consumer Protection Act?
No.
Okay.
No, the TCPA requires consent, and the level of consent can vary based on the kind of call, the kind of phone number, and what the call is about.
Okay.
So if you're going to send an SMS that is marketing related to a consumer, you need prior express written consent.
Okay.
If you're going to get that consent by text message, double opt-in is the best way to do it.
Okay.
Now, you could also do it via an online portal where the consumer sees all the required disclaimers.
Yep.
Make sure that their phone number is properly entered, and then they consent via checkbox typically, or typing in their name, to receive the SMS. So in that format, you didn't have a double opt-in.
Correct.
Right?
Yep.
But if they see a call to action, text sale to
like on a billboard
short code,
or something.
right?
Yep.
Exactly.
Okay.
If they text sale to a short code, or Joe's Pizza to a short code, and they take that action, and they get a responsive message from the platform that has all of the required disclaimers.
Okay.
If they text whatever the keyword back is, yes, opt in, right? If they text that back, that functions as their signature, but you didn't have to get their consent that way.
Okay.
So double opt-in is never mentioned anywhere in the TCPA, in the law, in the FCC's regulations about it, but it is an acceptable way to get consent.
Okay, so if a consumer sees a billboard and they text in the keyword like pizza to 12345 to opt in to receive marketing, sales-related messages, is just that message enough consent, or is the reason we do a double opt-in or we recommend a double opt-in is because it might be a chance that the consumer didn't see the terms and conditions on that billboard. Or maybe you took a photo of the billboard and it wasn't even on there.
Or your friend told you about it.
Exactly.
Right. So if you ever got sued for a TCPA violation, you can't prove that that consumer saw and consented to all of those terms and conditions.
Or it'd be hard because you'd be like, well, they saw the billboard, and then the consumer could say, well, I didn't see the billboard.
I don't want to get into the niceties of litigation, but I'll represent to you that you're going to be a long time into that case before you can prove to the judge that they actually saw those things.
Okay, and that costs money and
that
time.
Costs money, and you're going to depose them a year later.
Okay.
Do you remember what billboard you saw a year ago?
Yep.
So when they say, I don't remember, they're probably being honest.
Okay.
And you're going to have to go to trial about this?
Okay.
That is not an efficient way to conduct your business.
So with a double opt-in, though, you're sending them in the text message the information that they need to consent to, and them replying yes is a record that a company like Tatango would keep.
Exactly.
And then if there was a threat of a lawsuit and they said, oh, I didn't consent to any of that, we would just pull up the text message record.
Right, at 3:39 and 12 microseconds, you texted yes to the opt-in language. You can show the message flow. You send that to the plaintiff's attorney, and typically you never hear from them again.
Yep. Okay. And then if you're doing like a point of sale or a website opt-in, it's pretty obvious that they went to the website. I guess it would be the same. They could claim, well, I didn't scroll down far enough to see the terms and conditions. There's all kinds of ambiguity there, I guess. Like you could always come up with something.
But you'd always keep a record of what that website looked like.
Okay.
Right? And so you'd always keep a record of what that customer experienced when they gave their consent. And there have definitely been cases that go both ways about whether the consent was valid based on where that disclaimer language was.
How big it is, where it is.
How big it was, where it was in relation to the phone number, where it was in relation to the signature.
Okay.
So if you bury it, if you had to scroll to go see that language.
So it seems like, well, the double opt-in is not required. It's definitely not required. It's not in the TCPA. It seems like it's just kind of the best way to do it to avoid a lot of these issues of depositions and figuring out who saw what and the size of the font and where it's located, because on a website you could then send a text message which would include all the info and they could reply yes.
Correct. Under the TCPA.
Yeah.
And it has the added advantage of making sure that you're complying with what are called the CTIA guidelines.
Correct. Yeah.
So now that's not a law.
Yeah.
That's an industry guideline, good to follow. But
And I think that's where a lot of the confusion comes from, is they CTIA, TCPA, they think it all kind of is one law maybe.
It's acronym soup.
Yep.
But only one of them is law. The other one is essentially an industry best practice.
Yep.
But no one can ever sue you for not complying with CTIA guidelines.
Interesting.
There are no statutory damages. There are no damages for not complying with CTIA guidelines. The wireless carriers may be upset with you.
Yeah. And that could be a short code suspension, but you can't bring somebody to court for that.
No.
Yeah.
No.
And
So-
that's main concern is court, because the damages are what, $500 to $1,500 per text message?
Exactly.
Yeah, so you don't want to screw this up.
You don't want to rely on the single message billboard method.
Yeah. And as I always say, I'm pretty sure you agree, is when it comes time to like crafting an opt-in message, process, terms and conditions, this is not something you can just copy from another person's website, right?
No.
This is something you should hire an attorney for?
It should be tailored to your campaign.
Okay.
And even across campaigns, right? I mean, different campaigns have different TCPA implications. Like I said in the beginning, where are the calls going? What kind of phone number? What are the messages about? There are a number of variables that you need to think about and make sure that the campaign itself is TCPA compliant.
So blanket statements maybe work for a small business, but for anybody that is concerned about TCPA, that has a big, large brand that they need to protect, hire an attorney and really go and figure out what specifically needs to be in their terms and conditions, what the opt-in flow, everything even small businesses.
Set it and forget it doesn't even work for brownies.
Yeah.
Every oven varies, right? I mean, you have to.
That makes sense.
Think about these things because the regulations have so many variables.
Yep.
And they change all the time.
That's true. Isn't the TCPA always evolving, court cases?
Exactly. There are outcomes in different what are called circuits around the country where something may be fine in the First Circuit in New England, but the Northern District of Illinois has a very different interpretation of what the TCPA actually means. So there may be sensitivities there, and you want to make sure that you're complying with the highest standard.
Interesting. So this might also be a reason, too, why going to an attorney that is TCPA, like a specialist or something.
Right.
I'm not trying to promote you, but somebody that actually knows, what the TCPA and all the different nuances of it, rather than just a general business attorney.
It's the second most prevalent kind of litigation in federal court.
Wow.
Published decisions come out every day. And
so you have to be following it all the time.
If you're not, you're at risk.
Yeah, and you don't want to be at risk because $500 to $1,500 per text message, and that's per text message times how many text messages you send them, times how many people are on that list. You're talking billions of dollars if you have millions of subscribers.
Exactly.
Oh man. Okay, so today we learned that the double opt-in, while it's not required or not in the law of the TCPA, it is best practices and it protects you from a lot of kind of the litigation, the issues that could happen with TCPA. So interesting stuff today. Again, Joe Bowser with Innovista Law and the TCPA Defense Force, and I'm Derek Johnson with Tatango.com.
Thanks, everybody.
Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.